Welcome back to Artificially Informed, the podcast series that takes an in-depth look at the Florida Attorney General's Government in the Sunshine Manual 2025 edition. As always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 5, we continue our exploration of Part 1, Section C, What Meetings of Members of Boards Are Covered. Application of the Sunshine Law 2. We'll be navigating pages 24 through 31 of your manual. Our discussion will cover fact-finding or inspection trips, informal discussions, workshops, organizational sessions and election of officers, investigative meetings, and a comprehensive look at litigation meetings, including settlement negotiations and strategy sessions, strict compliance requirements, permitted discussions during closed sessions, who can attend, and the determination of conclusion of litigation, as well as the risk management exemption. Let's begin by understanding how the Sunshine Law applies to official trips and informal discussions. Segment 1, fact-finding or inspection trips, informal discussions, workshops, organizational sessions. Starting on page 24, we examine fact-finding or inspection trips. The Sunshine Law generally does not prohibit advisory boards from conducting inspection trips, provided that the board members do not discuss matters which may come before the board for official action. This principle was supported in Bigelow v. House, 291 Southern 2nd, 645, Florida 2nd District Court of Appeal, 1974. Attorney General Opinion 02-24 also states that 2 or more members of an advisory group making recommendations on proposed development may conduct vegetation surveys without subjecting themselves to the Sunshine Law, as long as they don't discuss recommendations. However, the fact-finding exception to the Sunshine Law does not apply to a board with ultimate decision-making authority. In Finch v. Seminole County School Board, 995 Southern 2nd, 1068 Florida 5th District Court of Appeal, 2008, the court held that a district school board, as the ultimate decision-making body, violated the Sunshine Law when its members, along with school officials and media, took a bus tour of neighborhoods affected by a proposed rezoning. This was a violation even though board members were separated and did not discuss preferences or vote during the trip. The court refused to adopt a rigid rule prohibiting out-of-county workshops, instead applying a balancing test between public access and the board's needs. Informal opinion to Sugarman, August 5, 2015, echoes this, stating that a pension board is not authorized to travel out of state to meet with financial consultants. Furthermore, in Citizens for Sunshine, Incorporated versus School Board of Martin County, 125 Southern 3rd, 184, Florida 4th District Court of Appeal, 2013, 3 school board members violated the Sunshine Law when they visited an adult education school and conversed with staff and students, because the undisputed evidence showed that the defendant board members, without providing notice, conducted a meeting at the adult education school relating to matters on which foreseeable action would have been taken. Compare Citizens for Sunshine versus City of Sarasota, number 2013, California 00753, 2, Florida 12th Circuit Court, July 8, 2016, affirmed subnum, Citizens for Sunshine, Incorporated, versus Chapman 225, Southern 3rd 810, Florida 2nd District Court of Appeal, 2017, where a city commissioner speaking about city issues at a private event, with another commissioner in the audience, did not violate the Sunshine Law. Next, on page 25, we delve into informal discussions, workshops, organizational sessions, and election of officers. The Sunshine Law extends not only to formal action, but also to the discussions and deliberations of a public board or commission. It does not require a quorum to be present or an item to be listed on an agenda for a meeting to be subject to Section 286.011 Florida statutes. As the Florida Supreme Court said in Town of Palm Beach versus Gradison, 296 Southern 2nd, 474, Florida 1974, collective inquiry and discussion stages are embraced within the statute's terms. Therefore, the law applies to any gathering, whether formal or casual, of two or more members of the same board or commission to discuss some matter on which foreseeable action will be taken by the public board or commission. This was affirmed in Sarasota Citizens for Responsible Government versus City of Sarasota, 48 Southern 3rd, 755, Florida, 2010. See also City of Miami Beach versus Burns, 245 Southern 2nd, 38, Florida, 1971, and Board of Public Instruction of Broward County versus Doran, 224 Southern 2nd, 693, Florida, 1969. As a special concurrence in Paris versus State, 359 Southern 3rd, 1178, Florida 4th District Court of Appeal, 2023, succinctly puts it, there is no such thing as an informal conference or unofficial caucus or pass-you-in-the-hallway information gathering or sharing by two or more government officials subject to the Sunshine Law, which would thereby remove such communication from the Sunshine Law's ambit. Such meetings have been deemed illegal if they lead to the unlawful crystallization of secret decisions to a point just short of public discussion and ceremonial acceptance. The public is interested in how and why officials decide to act, not just the final decision. As the court recognized in Times Publishing Company versus Williams, 222 Southern 2nd, 470, Florida 2nd District Court of Appeal, 1969, it is the entire decision-making process that the legislature intended to effect by the enactment of the statute. Thus, two members of a civil service board violated the Sunshine Law by holding a private discussion about a pending employment appeal during a recess of a board meeting. Citizens for Sunshine, Incorporated versus City of Sarasota, number 2010, California, 4387 November, Charlie, Florida, 12th Circuit Court, February 27, 2012. Similarly, the Attorney General's office has advised that gatherings such as a public forum hosted by a city council member with other city council members invited to attend, Informal Opinion to Jove, January 12, 2009, executive work sessions of a housing authority board, Attorney General Opinion 76-102, workshop meetings of a planning and zoning commission, Attorney General Opinion 74-94, and conference sessions held by a town council before its regular meetings, Attorney General Opinion 74-62, are all subject to the Sunshine Law. However, Attorney General Opinion 04-58 noted that a coincidental unscheduled meeting of two or more county commissioners to discuss emergency issues with staff during a declared state of emergency is not subject to Section 286.011 if the issues do not require action by the county commission. The Sunshine Law also applies to an organizational session of a board, Ruff versus School Board of Collier County, 426 Southern 2nd, 1015, Florida 2nd District Court of Appeal, 1983, discussions between two members of a three-member complaint review board regarding their selection of a third member are subject to Section 286.011 Florida statutes. Attorney General Opinion 93-79. Additionally, the Sunshine Law is applicable to meetings held to elect officers of the board, Attorney General Opinions 72-326 and 71-32, which specifically state that boards may not use secret ballots to elect officers. Therefore, the Sunshine Law applies to all functions of covered boards and commissions, whether formal or informal, that relate to the board's affairs and duties, as stated in Monroe County versus Pigeon Key Historical Park Incorporated, 647 Southern 2nd, 857, Florida 3rd District Court of Appeal, 1994. The Sunshine Law does not provide that cases be treated differently based upon their level of public importance. For example, Informal Opinion to Nelson, May 19, 1980, advised that a meeting with a congressman and city council members to discuss federal budgetary matters which vitally concern their communities should be held in the sunshine due to the high likelihoods of discussion of public business and potential decision making. Segment 3. Investigative meetings and litigation meetings. Let's turn to investigative meetings on page 26. The Sunshine Law is applicable to investigative inquiries of public boards or commissions. The fact that a meeting concerns alleged violations of laws or regulations does not remove it from the scope of the law. Attorney General Opinion 74-84, Ann Canny v. Board of Public Instruction of Alachua County, 278 Southern 2nd, 260, Florida, 1973. A number of statutory exemptions to the Sunshine Law have been enacted to close meetings of some agencies, typically state agencies, when those agencies are making investigatory determinations. For example, Section 112.324, subsection 2, paragraphs C, D, and E, Florida statutes, provides that any proceeding related to a complaint, referral, or preliminary investigation conducted by the Commission on Ethics or other specified entities is exempt from open meetings requirements until the complaint is dismissed as legally insufficient. The alleged violator requests in writing that the proceedings be made public. The Commission on Ethics determines that it will not investigate a referral, or until the Commission or other specified entity determines whether probable cause exists to believe that a violation has occurred. Compare sections 4, 55.2, 25, subsection 4, and 456.073, subsection 4, Florida statutes, which state that meetings of probable cause panels of the Department of Business and Professional Regulation and Department of Health are exempt from the Sunshine Law until 10 days after probable cause is found or until confidentiality is waived by the subject of the investigation. Now we delve into litigation meetings beginning on page 27. In the absence of a legislative exemption, discussions between a public board and its attorney are subject to Section 286.011 Florida statutes, NAU versus Miami Herald Publishing Company, 462, Southern 2nd, 821, Florida, 1985, established that Section 90.502 Florida statutes, providing for the confidentiality of attorney-client communications under the Florida Evidence Code, does not create an exemption for attorney-client communications at public meetings. The application of the Sunshine Law to such discussions does not usurp the Supreme Court's constitutional authority to regulate the practice of law, nor is it at odds with Florida bar rules providing for attorney-client confidentiality. However, Section 90.502, subsection 6, Florida statutes, clarifies that a discussion or activity that is not a meeting for purposes of the Sunshine Law shall not be construed to waive the attorney-client privilege. Collier County Public Schools versus Mason Classical Academy Incorporated, 342, Southern 3rd, 753, Florida 2nd District Court of Appeal, 2022, observed that Section 90.502, subsection 6, Florida statutes, permits school district employees to claim the attorney-client privilege if they can establish that their conversations with counsel were protected by the privilege. There are statutory exemptions, however, which apply to some discussions of pending litigation between a public board and its attorney. A. Settlement negotiations or strategy sessions related to litigation expenditures. Section 286.011, subsection 8, Florida statutes, states, notwithstanding the provisions of subsection 1, any board or commission of any state agency or authority or any agency or authority of any county, municipal corporation, or political subdivision, and the chief administrative or executive officer of the governmental entity may meet in private with the entity's attorney to discuss pending litigation to which the entity is presently a party before a court or administrative agency, provided that the following conditions are met. Subsection 1. Strict compliance with statutory conditions. It has been held that the legislature intended a strict construction of Section 286.011, subsection 8, Florida statutes. City of Dunalon versus Aaron, 662 Southern 2nd, 1026, Florida 5th District Court of Appeal, 1995. The court noted that the clear requirements of the statute are neither onerous nor difficult to satisfy. Accord School Board of Duval County versus Florida Publishing Company, 670 Southern 2nd, 99, Florida 1st District Court of Appeal, 1996. While Section 286.011, subsection 8, Florida statutes, does not specify who calls the closed attorney-client meeting, it requires that the governmental entity's attorney shall advise the entity at a public meeting that he or she desires advice concerning the litigation. Thus, the exemption merely provides a governmental entity's attorney an opportunity to receive necessary direction and information from the governmental entity regarding pending litigation. Attorney General Opinion 04-35. Accordingly, one of the conditions that must be met prior to holding a closed attorney-client meeting is that the city attorney must indicate to the city council at a public meeting that he or she wishes the advice of the city council regarding the pending litigation to which the city is presently a party before a court or administrative agency. Informal Opinion DeVock, July 11, 2001. If the city attorney does not advise the city council at a public meeting that he or she desires the council's advice regarding the litigation, the city council is not precluded from providing such advice to the city attorney, but it must do so at a public meeting. The requirement that the board's attorney advise the board at a public meeting that he or she desires advice concerning litigation is not satisfied by a previously published notice of the closed session. Such an announcement must be made at a public meeting of the board. Attorney General Opinion 04-35. The request may be made during a special meeting provided that the special meeting at which the request is made is open to the public, reasonable notice has been given, and minutes are taken. Attorney General Opinion 07-31. In City of Dunalon versus Aaron Supra, the court said that a city council's failure to announce the names of the lawyers participating in a closed attorney-client session violated the Sunshine Law. The court rejected the city's claim that when the mayor announced that attorneys hired by the city would attend the session but did not give the names of the individuals, his substantial compliance was sufficient to satisfy the statute. Compare Zork versus City of Vero Beach, 722 Southern 2nd, 901, Florida 4th District Court of Appeal, 1998, noting that deviation from the agenda at an attorney-client session is not authorized. While such deviation is permissible if a public meeting has been properly noticed, there is no case law affording the same latitude to deviations in closed-door meetings. Subsection 2. Permitted discussions during closed session. Section 2, 8.6.011, subsection 8, paragraph B, Florida statutes, states that the subject matter of the meeting shall be confined to settlement negotiations or strategy sessions related to litigation expenditures. If a board goes beyond the strict parameters of settlement negotiations and strategy sessions related to litigation expenditures and takes decisive action, a violation of the Sunshine Law results. Zork versus City of Vero Beach, 722 Southern 2nd, 900 Florida 4th District Court of Appeal, 1998. And see Attorney General Opinion 99-37, which states that the closed meeting exemption may be used only when the attorney for a governmental entity seeks advice on settlement negotiations or strategy relating to litigation expenditures. Such meetings should not be used to finalize action or discuss matters outside these two narrowly prescribed areas. Accord Attorney General Opinion 04-35. Section 286.011, subsection 8, Florida statutes, simply provides a governmental entity's attorney an opportunity to receive necessary direction and information from the government entity. No final decisions on litigation matters can be voted on during these private attorney-client strategy meetings. The decision to settle a case for a certain amount of money under certain conditions is a decision which must be voted upon in a public meeting. School Board of Duval County versus Florida, Publishing Company, 670 Southern 2nd, 99, Florida 1st District Court of Appeal, 1996, quoting staff of Florida, House of Representatives Committee on Government Operations, Committee Substitute for House Bill 491, 1993, Final Bill Analysis and Economic Impact Statement 2, Florida State Archives, at page 3. Thus, the settlement of a case is exactly that type of final decision contemplated by the drafters of Section 286.011, subsection 8, which must be voted upon in the sunshine. Zork versus City of Vero Beach, 722 Southern 2nd 901, Accord Attorney General Opinion 08-17, which states that any action to approve a settlement or litigation expenditures must be voted on in a public meeting. Accordingly, a court found that a city did not comply with Section 286.011, subsection 8 Florida statutes when it held closed meetings that covered a wide range of political and policy issues not connected to settlement of pending litigation regarding a comprehensive plan amendment or litigation expenses relating to the pending cases, which at that point were on appeal. While some of the discussion at these meetings did in fact involve the costs associated with the pending litigation, by and large the meetings pertained to finding a way to readopt the comprehensive plan amendment that had been invalidated by the court and to avoid future litigation regarding the readopted amendment. Anderson versus City of St. Pete Beach, 161 Southern 3rd 548, Florida 2nd District Court of Appeal, 2014. Similarly, a city council violated the Sunshine Law where the great majority of the discussion at an attorney-client session concerned the specifics of a proposed amendment to the city's trespass ordinance, which was designed to address concerns expressed in a federal court decision finding the ordinance to be unconstitutional. City of St. Petersburg versus Wright, 241 Southern 3rd, 903, Florida 2nd District Court of Appeal, 2018. The participants at the closed meeting did not limit themselves to discussing settlement or litigation expenditures. See also Freeman versus Times Publishing Company, 696 Southern 2nd, 427, Florida 2nd District Court of Appeal, 1997, where discussion of methods or options to achieve continuing compliance with a federal desegregation mandate, such as modifying school zone boundaries to achieve racial balance, had to be held in the sunshine. Compare Bruckner versus City of Dania Beach, 823 Southern 2nd, 167, Florida 4th District Court of Appeal, 2002, where a closed city commission meeting to discuss options to settle a lawsuit, including resolution modification, was authorized because the commission neither voted, took official action to amend the resolution, nor did it formally decide to settle the litigation. Subsection 3. Entity involved in pending litigation. Section 286.011, subsection 8, Florida statutes, permits an entity to use the exemption if the entity is presently a party before a court or administrative agency. For example, a city council and its attorney may hold a closed-door meeting pursuant to this statute to discuss settlement negotiations or strategy related to litigation expenditures for pending litigation involving a workers' compensation suit against the city because of the system prescribed in Chapter 440, Florida statutes operates as a means of adjudicating workers' compensation claims and would be considered litigation before an administrative agency. Attorney General Opinion 96-75. In Brown v. City of Lauderhill, 654 Southern 2nd, 302, Florida 4th District Court of Appeal, 1995, the court said it could discern no rational basis for concluding that a city is not a party to pending litigation in which it is the real party in interest. And see Zork v. City of Vero Beach, 722 Southern 2nd, 900, Florida 4th District Court of Appeal, 1998, where a city was presently a party to ongoing litigation by virtue of its already pending claims in bankruptcy proceedings, and Attorney General Opinions 09-15, exemption applicable when city is real party in interest of a pending lawsuit despite not being a named party at the time of the meeting, and 08-17, healthcare district may hold a closed attorney-client meeting to discuss settlement negotiations and strategies related to litigation expenditures for pending litigation, in which its wholly owned subsidiary holding company is the named party. Although the Brown decision established that the exemption could be used by a city that was a real party in interest on a claim involved in pending litigation, that decision does not mean that an agency may meet in executive session with its attorney where there is only the threat of litigation. See Attorney General Opinion 04-35 and 98-21, which state that the Section 286.011, subsection 8, Florida statutes exemption does not apply when no lawsuit has been filed, even though the parties involved believe litigation is inevitable. Similarly, Section 286.011, subsection 8, Florida statutes may not be used to conduct a closed meeting during a mandatory arbitration proceeding when there is no pending legal proceeding in a court or before an administrative agency. Attorney General Opinion 13-17 and see Attorney General Opinions 06-03, exemption not applicable to pre-litigation mediation proceedings, 09-14, exemption not applicable to discussion of terms of mediation and conflict resolution proceedings under the Florida Governmental Conflict Resolution Act, Section 164.101 through 164.1061, Florida statutes, and 09-25. Town Council, which received pre-suit notice letter under the Burt J. Harris Act, Section 70.001, Florida statutes, is not a party to pending litigation for purposes of Section 286.011, subsection 8, Florida statutes. Informal opinion to Barrett, February 17, 2016, also advises that a board is not authorized to use the exemption to discuss a pending investigation and subpoena where there is no ongoing judicial or administrative proceeding. Subsection 4, persons authorized to attend closed session. Only those persons listed in the statutory exemption, the entity, the entity's attorney, the chief administrative officer of the entity, and the court reporter, are authorized to attend a closed attorney-client session. Thus, other staff members, consultants, or officials are not allowed to be present. School Board of Duval County versus Florida Publishing Company, 670 Southern 2nd, 101. Florida First District Court of Appeal, 1996. C. Zork versus City of Vero Beach, 722 Southern 2nd, 891. Florida 4th District Court of Appeal, 1998. Review denied, 735 Southern 2nd, 1284. Florida, 1999. Which found that a city charter provision requiring that the city clerk attend all council meetings does not authorize the clerk to attend a closed attorney-client session. A municipality may not authorize what the legislature has expressly forbidden. Attorney General Opinion 01-10, Clerk of Court, not authorized to attend, and Attorney General Opinion 09-52, Attorneys representing superintendent not authorized to attend closed session to discuss settlement of administrative action in which school board is the named party. Compare Attorney General Opinion 95-06, which states that Section 286.011, subsection 8, Florida statutes, does not authorize the temporary adjournment and reconvening of meetings in order for members who are attending such a session to leave the room and consult with others outside the meeting. Since the entity's attorney is permitted to attend the closed session if the school board hires outside counsel to represent it in pending litigation, both the school board attorney and the litigation attorney may attend a closed session. Attorney General Opinion 98-06, C. Zork versus City of Vero Beach, 722 Southern 2nd, 898, Florida 4th District Court of Appeal, 1998, where attendance of special counsel was authorized, and Attorney General Opinion 08-42, qualified interpreters for the deaf are treated by the Americans with Disabilities Act as auxiliary aides and may attend litigation strategy meetings to interpret for a deaf board member. Compare Attorney General Opinion 15-13. Mayor who is a voting member of the City Council is not precluded from attending closed session relating to pending litigation in which City Council is a party even though plaintiffs have also sued the mayor in his individual capacity. Subsection 5, determination of conclusion of the litigation. Section 286.011, subsection 8, paragraph E, Florida statutes, provides that transcripts of closed meetings shall be made part of the public record upon conclusion of the litigation. See Attorney General Opinion 15-03, which states that a transcript of a litigation strategy session closed to the public while litigation was ongoing became a public record once the litigation concluded. Compare Everglades Law Center Incorporated versus South Florida Water Management District, 290, Southern 3rd, 123, Florida 4th District Court of Appeal, 2019, noting that mediation communications disclosed by a governmental agency during a closed session must be redacted from the meeting transcript. When it becomes public record, the exemptions for mediation communications in sections 44.102, subsection 1, and 44.405, subsection 1, Florida statutes are not inconsistent with the requirements of section 286.011, subsection 8, paragraph E, Florida statutes. The statute does not recognize a continuation of the exemption for derivative claims made in separate subsequent litigation. Attorney General Opinion 13-13. For example, a transcript of a closed meeting to discuss settlement of a quiet title lawsuit became a public record upon final judgment in that case, even though the same parties were involved in an inverse condemnation lawsuit. Chmielewski versus City of St. Pete Beach, 161 Southern 3rd, 521 Florida, 2nd District Court of Appeal, 2014. Similarly, a claim for attorney's fees does not extend the exemption after final judgment and mandate issuance. Informal Opinion to Bootsie's, December 13, 2012. Accordingly, a dismissal with prejudice pursuant to a settlement agreement conferring continuing jurisdiction to enforce its terms operates as a conclusion of the litigation. Attorney General Opinion 15-03. By contrast, litigation that is ongoing but temporarily suspended by stipulation for settlement has not concluded for purposes of Section 286.011, subsection 8, Florida statutes, and meeting transcripts may remain confidential until conclusion. Attorney General Opinion 94-64, and see Attorney General Opinion 94-33, public agency may maintain confidentiality of strategy or settlement, meeting record until suit is dismissed with prejudice or applicable statute of limitations has run. An informal opinion to Bootsy Supra, legislative history of Section 286.011, subsection 8, Florida statutes, indicates that the legislature intended the exemption to continue through the appeals segment of the litigation. Compare Wagner versus Orange County, 960 Southern 2nd, 785, Florida 5th District Court of Appeal, 2007, which concluded that the phrase conclusion of the litigation or adversarial administrative proceedings for purposes of the attorney work product exemption from the public records law found in Section 119.071, subsection 1, paragraph D, Florida statutes, encompasses post-judgment collection efforts such as a legislative claims bill. In Attorney General Opinion 13-21, the Attorney General's Office observed that Section 286.011, subsection 8, paragraph E, Florida statutes, should be seen as a tool which governmental boards or commissions may employ in their discretion, but the statute should not be read as a prohibition against the release of such records prior to the conclusion of any litigation. Therefore, a city council, as the collegial body to which the exemption applies, may waive the exemption and release transcripts of meetings held pursuant to Section 286.011, subsection 8, Florida statutes, prior to the conclusion of litigation. B. Risk management exemption. Section 768.28, subsection 16, paragraph C, Florida statutes, states that portions of meetings and proceedings relating solely to the evaluation of claims or to offers of compromise of claims filed with a risk management program of the state. Its agencies and subdivisions are exempt from Section 286.011 Florida statutes. The minutes of such meetings and proceedings are also exempt from public disclosure until the termination of the litigation and settlement of all claims arising out of the same incident. Section 768.28, subsection 16, paragraph D, Florida statutes. This exemption is limited and applies only to tort claims for which the agency may be liable under Section 768.28 Florida statutes, Attorney General Opinion 04-35. The exemption is not applicable to meetings held prior to the filing of a tort claim with the risk management program, Attorney General Opinion 92-82. Moreover, a meeting of a city's risk management committee is exempt from the Sunshine Law only when the meeting relates solely to the evaluation of a tort claim filed with the risk management program or relates solely to an offer of compromise of a tort claim filed with the risk management program, Attorney General Opinion 04-35. Unlike Section 286.011, subsection 8, Florida statutes, Section 768.28, subsection 16, Florida statutes, does not specify the personnel who are authorized to attend the meeting. See Attorney General Opinion 00-20, advising that personnel of the school district who are involved in the risk management aspect of the tort claim being litigated or settled may attend such meetings without jeopardizing the confidentiality provisions of the statute. Thanks for listening. In our next episode, Episode 6, we'll continue exploring what meetings are covered, focusing on personnel matters, purchasing meetings, quasi-judicial matters, security meetings, social events, and virtual meetings. Until next time, remember, the truth dies in the dark, so let's leave the light on.